Hi, everybody, and thanks for joining us today. I'm Perry Green. I'm CFO and Senior Wealth Strategist at Waddell & Associates. I'm going to be joined today by Mike Adams, who is a partner at Evans and Petrie. Mike and I have done a lot of work together over the last 15 to 20 years. So what we want to talk about today is estate planning, and specifically, not just the general estate planning, but specifically what are some things that you need to be thinking about today to take advantage of all the turmoil that's going on with the current corona crisis. So, like I said, we're going to go on and get started. And Mike, just want to touch base. I think you got us all zoomed in. And one of the things we're going to talk about is how things have changed over the last couple of months. And then, like I said, also, what do we need to look at going forward? So, Mike, if you can, I'm just kind of curious, what are some things that have changed up in your office over the last month and a half? I mean,
Here's one change.
it's the mask.
Right. And just remembering to wear it when we step out of our offices into the common area, because it's hard to breathe with them on. It fogs my glasses up. But of course we've been working from home, primarily either doing telephone calls, video calls. We've been coming into the office some. Legal services are defined as an essential service, and so sometimes as people have needed to sign documents in front of witnesses and notaries, we come in and of course we wipe down the door handles, do our hands, wear masks, and as few people in the room as possible. But we have executed some documents over the last 6 weeks as well.
So has it on the documents you've done, has a lot of it been kind of cleanup and making sure that everything's in place, or have you done a lot of tactical things as well?
Well, the first part was just kind of wrapping up the buildup in cases that we had, kind of from February and March. And some of those we got finished. We're more strategic in planning. Can you hear me okay, Perry?
Yeah,
okay.
Perfect.
Okay. And so, the first few weeks were just kind of wrapping up the stuff that was already in process. And then we kind of started to see a shift of that, people that basically just wanted to make sure their plans were up to date, that their healthcare documents were up to date, that the people that they had named maybe 10 years ago in a healthcare power of attorney, is that still the right person to pull the plug, so to speak? Or have they had a falling out with that person and that's the last person in the world that they want anymore? So I think one thing that's important for everybody, particularly given the times we're in, is just to make sure their documents are updated so they actually accomplish what they want and they name the people that they want. And there's some tax strategies that I know we're going to talk about as well, but estate taxes impact less people. And so I would say if anybody hasn't dusted off their estate planning documents in 6, 8, 10 years, that may be something they want to look at, because we've had a lot of changes in the law. We've of course had an unprecedented change in the economy and with this virus going around. So, and we got more changes in the law coming in 2026. So I think it's be a good time, good reminder for everyone to update their plan.
And I think that's one of the good things that's happened. All the terrible things have gone on in the last couple of months. It's made people kind of step back and think about what's really important. And like you mentioned, on the estate planning piece, taxes matter, asset protection matters, and all the rest of that stuff's important. But really, the key is making sure that what you want to have happen is what actually happens. So it's a good time for no other reason just to go back and revisit the document. So one of the things we talked about though earlier is, like you mentioned, we've had huge change in the economy. So stock market's down significantly. It's come back, a lot over the last few weeks, fortunately. Small business owners, if you've got a family-owned business and you're looking at doing a transition, I'm assuming this is a great time to come in and take advantage of all the turmoil in the market. So, the discounts have got to be significantly better than they were December 31st, I would expect.
Right, and not just discounts. I mean, the value of a lot of companies has decreased just simply because of the change in the economy. I've got one client that is a trucking company, and even they have stayed busy, but even they have had to shift and be nimble, and revenue is down a little bit and may continue. So the value of everyone's business is down, or not everyone's, but a lot of them. The value of the stock market is down, clearly, and interest rates are down as well. And that's kind of the perfect storm for planning, for gift planning, for anyone that's in a taxable estate. And we'll talk about that, various techniques. But yeah, because of the market, the economy, and the interest rates, now is a great time for gifting for anybody that's in a taxable estate situation.
Well, and I think that's one thing that's worth talking about. We've got some slides here on GRATs, a Grantor Retained Annuity Trust. And like you said, this section of the market is kind of the perfect time for a vehicle like this. You've got low interest rates, you've got depressed asset values, and if it's publicly traded stocks, if it's a solid family-owned business, you can be confident that long-term those assets are coming back. And if you're looking to make a transition, this is kind of the perfect time to do it. Mike, can you kind of walk us through tell us a little bit about what a GRAT is, how it works?
So as we said before, us estate planning attorneys love our acronyms. So GRAT stands for Grantor Retained Annuity Trust. It is a trust that you would create of which you're the beneficiary of annuity payments that are required to come back every year. So in your example there, where the person is starting off with $1 million, they put $1 million in a trust. Each year, they're required to get a payment back. And at the end of the term of the trust, whatever that is, and you get to pick that can be 3 years, 5 years, 7 years, 6 years, whatever. At the end of that term, you will have gotten your principal back plus whatever the applicable IRS interest rate is. And I think in your example, you've got 1.2%, but I think the GRAT rate is actually a little bit lower than that now. Didn't it go down to 0.8% this month?
Yeah, it even dropped in the last few days. So yeah.
Yeah, so it's even lower. In fact, at 0.8%, it's only been that low about 8 times in the last 40 years. So that gives you an indication of how low that rate is. And the payment that you are required to get back is just calculated as you show there. And I think what you're saying there is, what does the IRS assume will happen? Well, the IRS assumes you will make your 1.2%, you'll get your $1 million back plus 1.2%, and at the end of the trust term, there won't be anything left in the trust, because they are just, the IRS doesn't have a magic crystal ball, and so they don't know. So all they can work with is what are the interest rates in effect now. But what we know in reality, particularly with a depressed market, and I haven't seen what the market has done today, but I mean, it was down about a third. It was down from 30,000 to 20,000, and I know it's 23, 24, something like that now. But I think most of us feel that that's temporary and that we're coming back. And so we have a potential for maybe a greater than average market return over the next year or two. I'm not speaking to what markets are going to do. That's your job. But I'm just saying, even if we get back to the bench line, we will have had substantial appreciation. And the goal of the GRAT is, at the end of the day, at the end of the term of that trust, however much we beat the IRS interest rate by, and in your case here, we've got 10%, we will actually have gotten the appreciation, the future appreciation that we think is going to happen. We will have got it out of the person's taxable estate without using any annual exclusion, without using any lifetime estate tax exemption. It's kind of a freebie. It's kind of, you get extra here. And I should have started with, this really only applies to people that probably have more than, say, $12 million, a couple. because the estate tax exemption is even higher than that now, but in January 1, 2026, it's going to revert back to basically 12 million a couple. So for someone who's got 15 or 20 million and they want to start getting some assets out of their estate without using any exemption, a GRAT is a great tool to do that. And this is probably the best time in history to do a GRAT because of the low rates and the low market.
And like you said, basically, I'm keeping the value of what I put in. If I put $1 million in, at the end of the trust term, I'm going to have the $1 million back. I'm just getting the appreciation out to the children. And we've got another couple of slides just to take a look at. The first is, how we've looked at it kind of 3 different ways. What if we do it for 3 years, 5 years, 10 years? And if we do it at that, the rate last month was 1.2%. So try what's the difference between doing it 1.2 versus 5%. If you do it at a 5% rate, what you end up keeping is a little bit more than at the current low rates. But the real key to this, like you said, Mike, is what goes out, how much of that growth you get out. And so, the drivers are the interest rates, the real growth, and the term of the GRAT. So, at this point, how you said, what's the longest that you generally see GRATs done?
Yeah, probably the longest in your example here is 10 years. And the reason for that is for the GRAT to be successful is you have to survive the term of the GRAT. So if you die in year 9 of the GRAT before it ends, you don't lose, but you don't win. Just everything comes back into your estate. And so it's a function of what are the assets you're putting in there? What is your age? What is your health? Do you plan on doing GRATs every year? Because some people like to do shorter term GRATs called rolling GRATs. And I think you maybe have a slide on that too. But in those, every time you get a payment back from the GRAT, you just turn around and put that into a new GRAT. So 10-year GRATs are great if you're in great health and young right now, because the interest rates, like I said, have only been this low about 8 times in 40 years. And so you get to lock that interest rate in. If you wait a few years and the interest rates go up to 3 or 4%, then that's just more that has to come back to you and less that you can get out of your taxable estate. So, there's no magic bullet, one size fits all. It's based on a variety of different things, and everybody's different.
So really, the more the assets are going to grow, then the better the strategy works. Plus, the lower that IRS interest rate is, that allows you to have more out. So you're pulling 2 levers. How fast am I going to grow? And then how long, essentially, right?
That's right. And even what are you going to put in the trust? So if you were going to take the volatile, aggressive segment of your portfolio that maybe does a lot more of this type of stuff, the stuff that makes people nervous, the stuff that makes you get calls when it does all that, those are better designed for the short-term GRATs or rolling GRATs. And those are typically 2 or 3 year GRATs, with the idea there being that, it's doing a lot of up and down. Hopefully at the end of 2 years, we catch it on an uptick. And if we don't, no big deal. We'll just start over and we're just going to keep doing it again. And there have been all kinds of studies and Monte Carlo simulations done on those. The rolling GRATs work great for that volatile section of a portfolio. But if you had something that you thought was artificially low now that was going to take a steady climb over the next 5 years, then maybe a 5 or a 10-year GRAT would be the better choice, because like I said, we get to lock in those interest rates right now when perhaps that asset is artificially deflated because of the coronavirus effect on our economy.
And like I said, these are a good, they're a good vehicle pretty much all the time, but currently they kind of float up to the top of the list. And, in our example, kind of the tax savings that you'd be looking at with the 3 years is close to $100,000, going out to 10 years, you're about $350,000 worth of tax savings. So it's definitely worth, if you're in that position, it's definitely worth taking a little bit of time, look a little bit of headache and complication, but not much considering the total savings that you end up with. So,
that's right. And if you mean by headache and complications, you mean legal fees, then you're right there. Right. So, I mean, it is a legal document. It has to be prepared by a lawyer, and it should be someone that's experienced in estate planning, because there's a lot of technical language that needs to be in there. But really, anybody with more than, I'd say, $12 million estate now may want to start considering this. I think a lot of us have kind of quit thinking about estate taxes as much because the current exemptions are about $23 million per couple. But I guess not everyone realizes that that's a temporary thing, and that's going to go back down January 1, 2026. And the sooner you get ahead of that curve, the better, the more tax savings you can have.
Yeah. And so, that's a little bit on the high end. What are some other things that are worth looking at doing as far as using trust for asset protection, in addition to just the estate planning piece?
Well, in Tennessee, we have some great trust laws for asset protection. In fact, we have been ranked number 3 out of 50 states by a lawyer out in Nevada who kind of does a survey every year of what every state's laws are, tax laws, trust laws, et cetera. And so we actually have several tools. Probably the most common is something called a tenants by the entirety trust, or also referred to as a marital asset protection trust. That is for married couples to do. The neat thing about that is that trust is revocable, and the husband and wife can be their own trustees. And that's something that we typically have not had. Typically, you have to give up a little bit more control to get that protection. But the tenants by the entirety trust is just a revocable living trust that the husband and wife create together. They put assets in it, put their home in it, put their stock portfolio in it, and anything in that trust would be exempt from the separate claims of either the husband or wife. And it actually has the added benefit, all the traditional benefits of a living trust, which is to provide for a smoother transition when a person passes by keeping out of the court system.
And this is something where you don't necessarily, this applies even if you don't have a $10, $11 million estate. This gets you the asset protection in an early, and so thinking through, if my wife and I set one up, she has a car wreck and they sue her, the assets within the trust are protected.
Great point you made about this. This is a great tool for anybody. In fact, I'd argue that if you've got $50 million, you can afford a $5 million lawsuit better than if you've only got $5 million, right? So it's almost counterintuitive. It's almost like the less you have, the more you need this, because just like investing typically gets a little more conservative to protect the assets when people get older, I feel like, if you're retired and you don't want to go back to work, you need to protect what you've got pretty hard. And that includes things like, making sure you have an umbrella policy for your car insurance, making sure that it's more than $1 million. And then this is another step you can take by putting things in there. And it frankly, it builds on a type of protection we've had in Tennessee for 100 years, this tenants by the entirety. It just means that the wife has the right to use the trust assets for her entire lifetime, but so does the husband. So if the husband gets in a car wreck and they're suing the trust, they can't take those assets because it would interfere with the wife's right to use the entire assets for her entire lifetime. And so, I think as we approach retirement, all those types of things are important. And there's a couple of other trusts, different types of trusts as well that we can talk about that provide some asset protection. But I want to finish up this one first and see what else you had to say.
Yeah. Well, and so and you mentioned it's covered during both lifetimes. If the first spouse dies, do you lose all that coverage or what happens from there?
Great question. So it's actually unclear what happens to 100% of it because the statute is so new and it's infers that all of it might be protected. But what we know is that if husband has the car wreck and then they sue him and get a judgment and he dies, his half actually continues to be protected. The wife's half, it depends on whether it's structured as revocable or irrevocable because she's still living, remember, and she might want hers to be revocable so she can change it. But if she makes hers irrevocable, if we say when one spouse dies, the whole thing is irrevocable, we've at least got an argument that the surviving spouse's half is protected as well. Like I said, the statute implies that it is, but it doesn't just come out and say it. But we know that way at least half of it's protected. And that's to be contrasted with traditional tenants by the entirety without the trust. In that same scenario, if husband gets in a car wreck and someone sues and gets a judgment on if they did not have a trust, if they just owned everything as husband and wife, and then wife died, automatically by operation of law, those assets would pass to husband. And that's a bad thing because remember, the husband is the one that got in the car wreck and has a judgment against him, right? So traditionally, the tenants by the entirety was nice for some asset protection, but that could end when one spouse died. You couldn't do any trust planning with it because it passed automatically to the other spouse. And you couldn't do any estate tax planning with it because it just passed automatically to the other spouse. And I believe what our legislature did is say, look, more and more people are planning their estates with living trust. We've already got this asset protection way of owning things. Why don't we have the ability to have that same protection with a little more flexibility to allow planning? Because what our legislature is trying to do is make Tennessee kind of like the Delaware of corporations, right? Where it used to be everybody went to Delaware to incorporate. And so they're trying to get banks to bring trust business here because bank revenue they can tax. And particularly since we don't have an income tax on wages, they're always in favor of anything we can do to increase our tax base. And so between that trust and several others, Tennessee is kind of at the forefront of what you could almost call a trust revolution. I mean, in the last 15 years, we've seen a lot more trust used for a lot more things like asset protection.
So what are some of the other things that you're seeing that make sense right now?
Well, asset protection wise, one that we've had a little bit longer than that trust, not quite as popular because it's irrevocable and you can't be your own trustee. And that is referred to as a TIST. Again, our acronyms, Tennessee Investment Services Trust. Quick funny story aside on that we tried to pass that in 2006 and it was called the Tennessee Wealth Preservation Act. And there were a lot of lawyers on the committee. They were trying to get it through the legislature. Some plaintiffs' lawyers that sue people voted it down. They wouldn't let it get out of committee because it was it was a way to protect the assets from the lawyers. So the very next year they reintroduced it through the banking committee and called it the Tennessee Investment Services Trust, and it went right through the committee and passed on a vote. So that's why we have that weird name. But on that one, I would create a trust for my own benefit, but I have to name someone else to control the purse string. So if I want some of that money back and I've named you as trustee, I've got to pick up the phone and call you and say, hey, Perry, you're my trustee. Would you please consider giving me some of my own money back? And a lot of people don't really like to give up that control, even though I can retain the right to fire you as trustee and go name someone else as trustee. So it sounds kind of scary in that it's irrevocable, but I can retain 4 or 5 important powers. First, like I said, the ability to remove the trustee and appoint a friendlier trustee. Yep. Secondly, the ability to direct the investments, control how it's invested. So I don't have to bother the trustee with that. I can control that myself. I can retain the right to change who gets it after I die. Typically I set this up and it's after I go, it's probably going to my kids or something like that. But what if I have a falling out? So I can retain the right who gets it ultimately, and I can prevent you as the trustee from making distributions, say, to my kids. Even if they're beneficiaries, I can retain a veto power there. And that type of trust is really better to not hold everything. It is, maybe better for the rainy day fund. Something that if all else fails, we want to make sure we've got that protected. Because if you put everything in there, the courts have kind of ruled that no reasonable person would put all their money beyond their control, and they just don't believe that you don't have control. And they'll find as a matter of law that you do have control, and if you don't get it back, they'll throw you in jail. And that's what happened in the Anderson case out in California. The person said, it's impossible for me to get this back, the doctrine of impossibility. And the court came up with the doctrine of disbelief. We don't believe you, we hold you in contempt. And after he went to jail, somehow magically he was able to get some money out to satisfy the creditors.
It's amazing how that works out. So,
yeah.
So, I mean, kind of putting the bookends on this, the asset protection trust, the investment services trust you're talking about now, this is, you've had a large windfall, you want to protect it, and you want to have kind of money to start over again. You can't put everything in it. But by the entirety trust, that is something that you can put essentially all of your assets in and get that full coverage from the liability perspective.
And that's right. Because a lot of husbands and wives own everything jointly anyway. Yep. So you can't really argue that you put it in the trust to defeat a creditor when it was already protected as husband and wife. It's just a little more protected, along with the nice piece of avoiding probate court when you pass.
So help me think through, as far as assets to put in these trusts, what are the assets you don't want to put in a trust?
I'm glad you asked that, because that made another, made me think of another point. The first thing is cars. You don't want the automobile in there, because an automobile is the source of liability. That's like, opening the gate, let the dragon in the castle. We don't want that. And likewise, the other point I meant to mention a minute ago is that everyone needs to understand that this trust is protected from the separate creditors of either spouse, but not a joint creditor. So we have to be careful so that we don't have opportunities to accidentally create a joint liability. And the classic example is if husband and wife own the car together, and I'm picking on the husbands again, sorry guys, the husband gets in a car wreck. If the wife is the owner of the car as well, she's likely going to get named in that lawsuit. And so if that person is successful, because let's say someone is really harmed, they've now got a judgment against the husband and the wife. And so one thing that's important in doing these trusts is, like you said, some things we don't put in there, like the car. And not only do we leave the cars out, but the car that the husband primarily drives should be in his name, and the car that the wife primarily drives should be in her name. That's from an asset protection standpoint. Now, there are other things you can't put in there really, because like an IRA, individual retirement account, is really already held by a third-party custodian. It really is a form of a trust already. And they're already exempt under Tennessee state law anyway, just like 401ks are exempt under ERISA, a federal law. But pretty much everything else that does not entail liability, or that is not a source of liability, like a car or a boat or a three-wheeler. I don't think they even make three-wheelers anymore, four-wheeler. Things like that you would not put in the trust.
Well, and you mentioned IRA, that kind of hits one of the questions that's popped up. Is the law changed last year with deferrals on IRA distributions for inherited IRAs? Are you making any changes to the trust that you have set up already to handle this, to handle beneficiaries on IRAs?
So let me give you the good lawyer answer, which is it depends, right? It depends when that trust was done. And this kind of goes back to what we started off the whole webinar with, was that make sure your documents are up to date. Because 10 years ago, we were putting different provisions in than 5 years ago. So if I've done a trust probably the last 5 or 8 years, the documents I've done are not going to require a change because the document itself kind of builds in, you only do this if the law allows it. And they just changed that law as part of the act at the end of last year. The same one that changed the required beginning date from 70 and a half to age 72 also changed that when you inherit an IRA, you now only have 10 years to take all that money out and pay the income tax, whereas you used to have the opportunity to do that over your entire lifetime. And so in order to get that lifetime deferral or that gradual income tax, your document had to say specifically that any distributions that came out of the IRA into the trust had to then go out of the trust to the beneficiary. And that was great when that was over 40 years because it would take a long time for all that money to be sucked out of the trust for your kids or whoever. But now we've got to be very careful because when a person dies, and let's say they've got minor children that are 11 years old, we certainly don't want all of the retirement assets to come out of that trust within 10 years because that person would be 21 years old at that point. And so I'd say anybody that hasn't had their estate planning documents looked at in, I don't know, more than 5 or 6 years, if I've done it, or maybe even more recently if someone else has done it, just to take that provision out or to make it dependent on you only do this if the law allows, because they could change the law back. I mean, this, we don't know what I don't think they're going to change that back, but they could. And so it's still in the document. Now it's just an if-then type of thing.
Yeah, and I think kind of even the explanation for why they put it in was to raise revenue. So the odds that it gets changed back.
This stuff. Yeah, they had to pay for some of these other things.
Exactly.
They did. Yeah.
Right.
Yeah.
So speaking of revenue and other taxes, how taxes have changed up over the last few years. One thing that's happening is, and I got a question about this earlier too, is capital gains tax. So right now, if I inherit something, I get a basis step up. So, if it's my father bought some Berkshire Hathaway 30 years ago, he's got zero basis, I sell it and there's no capital gains. So if we end up doing some of these other trusts that you talked about, is there a way to kind of build in a mechanism where not only do you get the estate tax savings, but you get some capital gains tax savings? I mean, without all the details, but big picture, can something like that be done?
Yeah, and I think for the viewers too, it's good to kind of take a step back and explain what we're talking about by this step up in basis or basis adjustment. The easiest way to explain it is if you buy something for $10 and it goes to 100, you sell it, you pay tax on that profit of 90. But if you buy something for 10, it goes to 100, you die when it's 100, and your kids sell it for say 101, they pay tax only on the $1. So we adjust the income tax cost basis at date of death. And right now, with estate tax exemption of $23 million per couple, the estate tax only affects, they say, about 0.1%. It's not even 1%, it's 0.1% of the population out there. So most people are going to have extra exemption. And if you've got extra exemption, you can use that exemption to not pay estate tax, but to make sure that you are getting that step up in basis, maybe not just when the husband dies first, but later again when the wife dies. And the way you do that is through a formula, basically, that says, when I die, if I have extra exemption, or in that scenario where husband died first and wife may die later, or let me back up, because this actually may be something that a lot of your widows and widower clients might be interested in. I've got one right now where I'm doing this for a gentleman whose wife died about 6 years ago. So, 6-8 years ago, the standard planning was whoever dies first, let's create a credit shelter trust or a bypass trust, a trust for that surviving spouse to allocate their estate tax exemption to it. And let's say that couple had $5 million. and they put $2 million in the trust when the husband died. And now later the wife is getting older and she's got, say, 3 million. Well, all in together, they've got 5 million, which is still less than the $6 or the $12 million exemptions. And so we might want to, through some estate planning techniques, we might want to intentionally cause that prior trust, the family trust that was created when the husband died, we might now want that to be in the wife's estate so that we can wipe out those capital gains again. Does that help? That was kind of a long answer.
It does. So really what you're doing is in the instance where you've got a surviving spouse, you're trying to weigh for the children the estate tax cost versus capital gains tax cost, and whatever gives you a better answer, if there's a way to tweak it. Like I said, a lot of times there's the opportunity to work within the documents to then come in and get a better answer at the end of the day. So,
yeah, and I guess it's kind of three things. So for someone who's already had a spouse die, we could go back and fix that. For married couples who no one has died, we now include that formula language in advance, so it just kind of automatically happens when the spouses die. And then thirdly, when both spouses are deceased and it drops down a generation to children, when your child dies, we should have that same formula in there so we get the opportunity for that step up in basis and wipe out those capital gains at every one of those scenarios. And because we've got, the exemptions are so big, it's very likely that people will have extra exemption to take advantage of those formulas.
So perfect. So a lot of it is thinking about how to structure the estate. Is first of all, figure out what I want to see happen. But because the exemptions are at the point where they are now, you're not as limited by the taxes, it sounds like. So you've got most estates, you can really do, here's what I want to see happen. You can structure it to have assets distributed the way you want, and then come in and kind of bolt on some additional tax savings on the back end.
Yeah, that's right. And it really needs to be a formula, because we don't know what the estate tax exemption is going to be. Even if it does sunset back, it's still adjusted for inflation. We don't know what year people are going to die. So that formula just neat because it just makes it work either way.
And so, like we said, it's the last couple of months, I'm sure, has driven a lot of phone calls and the like in your office for people, that have stepped back and said, okay, we've got this pandemic going on. I want to be sure everything's in place. If after we come out of this over the next few weeks, few months and year, as life kind of returns to normal, how often do you try to come in and do the reviews with clients?
I think there are certain things that happen in a person's life that'll make it happen sooner. So like a death or a birth, or if you move, change states, things like that. Or if anybody that you've named as your power of attorney or executor or trustee, anything happens to them, clearly you should update then. But absent that, it's probably a good idea to sit down every 5 years with your estate planning attorney and just go through the documents to make sure that they still fit your circumstances and that the laws haven't changed so much that you'll have an unintended consequence, much like that 10-year payout of the IRA to a 21-year-old who's probably not, I don't know about you, Perry, but maybe at 20 years old, I didn't need $1 million IRA.
It could have ended badly. Yes. That could have been interesting. So, I mean, that's perfect. And then, Mike, anything else that we need to be thinking about as far, we've talked about estate taxes, we've talked about asset protection. Is there anything else that's really key to think about as you're drafting the estates?
One thing, back to the healthcare documents, one thing that I think a lot of people don't have, and not all attorneys do this, is what's called a HIPAA waiver. So typically, what you'll see in most estate planning packages is a healthcare power of attorney where you pick the person to make decisions for you, and then a living will that says, hey, if I'm terminal and I'm brain dead, it's okay to unplug me. Or those documents can actually be combined now into what's called an advanced care plan. But typically everyone names a spouse and then maybe some backups. Maybe that's a brother, maybe that's kids. Well, what if your spouse, the decision maker, is not the one in the hospital room when the physician comes in for a big update or a lab test or blood work, but your kids or your brother are? And so you would typically want them to be able to receive that information, but sometimes the hospitals, depending on the doctor and depending on the hospitals, may or may not release that information because of the HIPAA privacy law, which is a federal law which goes all across the country. So one of the things I do is I ask them, who would you want the doctors to be able to communicate with? Who would you want them to be able to give information to? This is not decision-making authority. That's spouse first and then whoever. And so that kind of usually broadens, to several different people. And I think that, from personal experience, I've had that issue myself, and it's very nice to have that HIPAA waiver. So that's one thing that a lot of people may not have. If they're updating their plan anyway, I would ask for a HIPAA waiver.
And I guess the thing you mentioned, or is if you move. So, if I live in Tennessee and I move to Montana, California, New York, wherever else, I guess at that point it makes sense to update documents as well. Right?
Yeah, you should really have it looked at because different states have different laws. For example, in Tennessee, your will has to specifically give your executor the power over real estate, and if you don't, then the real estate immediately vests in the beneficiaries, which there may be 5 beneficiaries, and that can be cumbersome from a perspective of trying to close on a house sale, let's say. Or maybe you want the executor you've named to one quarterback to control everything. So people moving here from other states like Arkansas with wills done in Arkansas aren't going to have that provision. So that's just one example. And it's probably not that they have to completely reinvent their estate plan, but there may be things in another state that they can take advantage of, or there may be things in the other state they need to avoid. So I would say they should get it looked at, and it may need to be tweaked.
Okay, like you said, it's just one of those major life events that causes an opportunity or an excuse to come in and revisit things.
I want to say one other thing about asset protection. I think we're getting close to run out of time, but that is, we've talked a lot about protection of the husband and wife while they're alive and the surviving spouse. Tennessee has good laws that when the husband and wife are both gone and you leave assets in trust for your kids, that provides a way to protect them as well. The older, more traditional way was to end those trusts at kind of a stair-step ages. So we saw a lot of, my child gets a third at 27, half of what's left at 30, and the balance at 35. Well, now we really don't want to terminate that trust because it just provides an opportunity to have it better protected. And so if anybody has got an old will or an old trust where they're leaving stuff outright to kids or with trusts that terminate for kids, I would encourage them to consider updating their plan so that trust runs for their child's lifetime, but their child can control it at whatever age they think their child is mature enough. So instead of gradually ending it, let the child take over at age 30 or 35, and that's just going to protect it a lot better, not only from lawsuits, but other types of things as well.
Perfect. And so that gives you, like you said, that there's a lot of flexibility that's come out in the last 5 to 10 years as far as the trust laws. So it's definitely worth going in if you haven't had a chance to look at your documents, if you haven't had a chance to update things, to get in and see not only what you have done, make sure it's what you still want, but then make the adjustments and take advantage of the opportunities that are here today. So Mike, thank you for joining us. I appreciate all your time that you've given us. If you're interested, for everybody else that's tuned in, if you would, you can text the state plans to 44222. That'll get you on our mailing list. Mine and Mike's contact information is here. So if there's anything that either one of us can do to help out, please let us know.
Thanks for having me. And with that, I'll have to remember to put my mask back on before I go back out in our common areas. We're not back full staffed yet. We started to, and then we kind of stopped. I think we decided we're going to wait another week or two before, we get everybody back in here. And the working remotely is working pretty well. And so I think some people will be back in the office, some people will be working remotely, but certainly we can come in if clients need to meet or if they need to sign documents, or we can continue to do exactly what we're doing right here. We can have Zoom calls or telephone calls as well. So thanks for having me, Perry.
Yeah, Mike, thanks again. Appreciate it. And thank everybody for tuning in.